Hello, welcome to the tutorial keypoint video for the second tutorial on W200. Started off by reviewing what we've done so far on sources of law, legislation, case law, and I spoke about research. Now there's a very good problem analysis flow diagram on page 97 of your manual, and that's very useful to look at and to go through the various stages. The important points are the need for the full picture. One of the things that you'll find as a solicitor is that your client will tell you their story, but it might not be all the facts. Before you can give a reasoned opinion, you need to make sure that you've got the full facts, and the same applies to legal research in the degree. The key legal skill isn't knowing the law, it's knowing where to go to look for the law. And the other thing is the importance of critical evaluation, weighing up the arguments, the assertions. Then we moved into statutory interpretation, and we had discussion groups, and these discussion points are worth thinking about. What are the problems in discerning Parliament's will? Do judges make law? And should judges make law? Again, it's worthwhile making a few notes in answer to those questions. We then looked at the tools of interpretation, and I introduced to the group a mind map. Now, I will be sending that out as part of the mailings. If you're not in my group and you haven't had this, please just drop me a line, jdavidmorgan@googlemail.com, and I'm happy to send you out a PDF of this map. Although actually you could do it yourself, because I didn't do anything inventive with this. What I did was to have a look at the structure of the chapter on statutory interpretation. And really there are 4 key points there. The rules of construction, the rules of language, the aids to interpretation, and presumptions. So I put those as off the main heading. And then each of those I broke down, again by subheadings in the book. So the rules of construction, the literal rule, the golden rule, the mischief rule, the purposive approach. And if you were doing this either on software to do mind maps, or as I do most of the time with a pen and paper, you can add on keywords which remind you about each of those rules of interpretation. Well, what does a literal rule mean? Just a couple of words there that you can bring back to mind. And the value of doing this is not only that it makes sense, it maps out the subject and makes it easier to read through, it puts down those links which you need to keep going for the examination. We then moved on to judicial precedents and discussed how it worked in practice. Again, this is worth doing. What I would also recommend is, if you get the opportunity, go down to see the Supreme Court or the Court of Appeal and see legal argument at that level going on, and you will see that you'll have one side putting forward what they argue are the relevant precedents. The other side will argue that they're not relevant and will put forward its own set of precedents. That judicial precedent, again, central to legal thinking. The English legal system, key points here, the structure of the courts, make sure you know which courts deal with criminal matters, which deal with civil matters, and how they're made up. Lots of information in your manual. And of course the personnel of the English legal system. Judges, the lawyers, the barristers and solicitors, the Lord Chancellor, who's also the Secretary of State for Justice and the law officers, non-legal personnel, juries and magistrates, and of course criminal procedure and civil procedure. On to TMA02. I know that TMA01 is due in just a few days' time. This is a looking ahead, but do think about these issues as you're reading in preparation for that. So question 1 is all about the declaratory theory of law. So definition. Lawyers love definitions. Explanation. And then most of all, critical evaluation. Get the evidence from judicial lawmaking in practice. And you can talk about you can give a general assertion of principle, you can talk about precedent, statutory interpretation, bring in the relevance of the doctrine of the separation of powers, and checks on judicial decision making. Most of all, in prepping for this TMA2, make sure that you get cases. They're really the key to legal writing. And most of all, get the conclusion in. Question 2, you need to talk about the need for statutory interpretation, and in looking at the traditional rules of construction, you need to describe and explain, compare and contrast, and to consider the relationship between the rules. And then do your own evaluation. What are the strengths, the weaknesses of having these set of so-called rules, and of each of them in between. Discuss other aids and again come to a conclusion. So thank you for watching this video. Use the manual, use mind maps or whatever other devices you find helpful, and put the concentration on critical evaluation. Thank you.